Hi, I'm Sabine, the Purpose Lawyer. Thank you for listening. Please don't forget to like and subscribe to this podcast. It really goes a long way. It helps us spread the good word. And if you or anybody you know is in the market for legacy or estate planning or business or trademarks, please reach out to our firm. It's the Ambitious Legacy Firm. We are licensed in New York and New Jersey, but we have service partners in all states. So we'd love to work with you. Asset protection, legacy planning, trademarks. We got you. All right. So it's the ambitiouslegacyfirm.com. Now let's get into the episode. Welcome to another episode of the Ambitious Legacy Podcast. I'm your host, Sabine, the Purpose Lawyer. Thank you for listening and thank you for helping me be on purpose. So guys, today is just me and you. I wanted to kind of go through one of the most frequently asked questions that I get regarding trust and estate. So you guys know this is, we talk here about legacy. We talk about protecting your assets and we talk about, all the different ways that you can and should and all the things that are involved with that. And so, one of the main topics in asset protection is trust. Why? Because it's a really versatile tool that allows you to have a lot of control over your assets. It allows you to put a plan in place to make sure that, your loved ones are protected if something were to happen to you unexpectedly, which happens all the time. And so it's one of the tools that we use. Not perfect for everybody. And it's not that everyone must have one, but most people with a significant amount of assets, I say at least over 100K, usually some real estate, should consider whether a trust is right for them. Like those doctor commercials where they say, talk to your doctor about this medication. So that's the thing. Talk to your legal professional about whether it's right for you. But I kind of wanted to get into what it is because a lot of people find it sort of mysterious. Like, I don't understand really like what is a trust? How does it actually work? And so I wanted to kind of dissect that a little bit. And so high level, which I've said before, trust is like a contract. It's a contract between the person who creates it, their trustee, which could be the same person in certain circumstances, and the beneficiary. So it's really for the benefit of the beneficiary. So the beneficiary is whoever is going to benefit from their assets, from their, cash, real estate, stock accounts, all that good stuff. That's who your beneficiary is. And you have the flexibility to pick and choose whomever you want. And that's the really beautiful thing about planning is that you get to decide and you get to have your say and your assets go exactly how you want them to go. And the bigger overarching thing here is that we all are here to sort of make a mark on this world. And I don't want to sound all woo-woo on you, but like it's really true. Why? Because I said it. It's true. We're here for a purpose. Everyone has their own purpose, and it should be more than just living your life for the here and now. But think about how beneficial your life is, or the things that you have benefited for in your life because someone else was here and because someone else paved the way for you. So we should just be thinking about preservation and passing on and creating and leaving that legacy that we are here to create. So let's get into talking about trust, right? So what I told you what a trust is. And, a lot of times people ask me, can I do a trust on my own? Can I just do it DIY? Or they want to know how come there's like a higher cost when it comes to creating a trust versus a will. And so a trust can be very technical because of the fact that what you're doing is you're giving this document or you're transferring to the trustee of the document all of the rights that you essentially have over your assets. So the rights that you have to your accounts, the rights that you have to your property, the rights that you have to everything that you essentially own. So we want to make sure that it's clear. We want to make sure that, it has all of the language that's necessary to do that. And not only that, because it's similar to a contract or it's considered a contract under the law, if there are things in there that's vague, right? It's not clear. No one kind of understands what was meant. And there's just things, if there's a lot of gray area, it can actually cause your trust to be brought into court. Right. So the whole purpose of really doing a trust, and I would say one of the purposes, right, of really doing a trust is to avoid what we call probate. And probate is where your estate has to go through the court system, and the judge gets to basically make decisions about your estate in terms of, what did you mean? Who did you want your assets to go through? What would you have intended? And that's what we really don't want, because most of the time the judges don't understand the dynamics of all of our families, right? They don't understand, who's who. They just assume that you would want your siblings or your parents, or, if there's no one else, your children, whatever the case is. They just assume that's who you would want. But many of us have different either views on life. Maybe we want to, maybe we have a best friend or a niece or nephew, or maybe we want to bless a charity, whatever it is. We each are unique individuals. We each have a different legacy to leave, and we each get to decide what that is. So you don't want to kind of leave it up to a cookie cutter, the court gets to decide. So that's one. And so that's the whole point of us doing a trust, is to sort of avoid that court system. Another reason why we want to avoid the court system is because it costs money. It causes a delay if somebody's there waiting to benefit from your estate, like a child or somebody who's really dependent. It's going to be a delay. It's going to, take away from the value of your estate, and it's public. So all of your family's business is out there, right? Okay. But I've said these things before. So that's one of the reasons, why we want to avoid the court system. And so when a contract, I was talking about if the trust is vague, if it's not clear. When a contract is not clear, then the only way to make it clear is to have a judge to determine, what did you mean? What was trying to be said here? And so that leaves, room for interpretation. And then that leaves room for your wishes to be changed. And we don't want that. We want things to go exactly how you decided. So I had I brought a prop today. So I brought a trust that we have drafted in my office. And just so you could see how many pages this trust is, this is actually a very simple trust for one of our clients. And it's just shy of 100 pages. And the reason for that is because we don't want you to hire an attorney, go through the trouble of putting all of your wishes together and listing all of your assets and coming up with a plan just to be back at square one, right? So we try to be as thorough as possible, and you want to make sure that, you are working with an attorney or professional who kind of has that mindset. We want to make things as thorough as possible. There are certain areas of the law that you can DIY, right? There are certain areas of the law that can be automated and cut and paste. And, even though we do use software to help us so that we're not writing every single word, it takes a lot of time to analyze and make sure, well, if this happens, then what's going to happen here? Or if we draft it this way, we use this language, is it going to have the outcome that the client wants? Because everybody's life is different and there's different dynamics. So it really takes a lot of time and skill to really put these things together. So what I wanted to actually get into, now that you have that framework, is, what exactly is in a trust and how does that sort of help me or protect me? So I'm going to go through some of the clauses. Obviously, I can't tell you every single thing because we don't have enough time and you don't want to hear it either. So, but I want to give you some of the high level things that are in the trust so that you kind of know, what is all this language talking about? So one of the first sections is the name of the trust, obviously, right? So we have to name the trust something. And typically, you have the flexibility to name the trust pretty much anything you want. We try to give some framework because it makes it kind of easier for people to understand. Say your trust needs to do a transaction with a bank or with the lender or, anything like that. Maybe needs to do a real estate transaction or anything that a trust needs, any business a trust needs to sort of conduct. We kind of want to streamline it a bit because we don't want it to just be something crazy like Jim and Joe's Deli. Obviously it's what? That's a trust. You don't want it to be that. So we'll typically have you say it's a living trust, which is a typical type of run-of-the-mill trust that almost everybody's plan is going to include. Even if they have an advanced, sophisticated plan, they might still include a living trust or a revocable trust, right? This is the type of trust that you put in place that you can change. You have the flexibility within this trust to, make decisions, change your mind, add assets, remove assets, all that kind of fun stuff. Typically, it's going to be, whatever you want to name it, followed by living trust, right? And that's, like I said, just to sort of make sure that it's streamlined. The law doesn't really say that you have to, stick to that. But in order to make it easier for running the trust and logistics, you want to kind of have it, form that way. So, you could name it anything you want. Most people, just because you're like, I'm not creative, I don't know what I want to name this trust, most people will go with their last name. I typically don't recommend first and last name because even though a revocable trust or living trust does not give you anonymity, right? It doesn't necessarily protect your identity. Whatever anonymity you do have, you're kind of just like giving that all away when you use your whole full name. So that's just one, tip to not necessarily name it that. However, you do have that flexibility to name it whatever you want. So you can get creative there. And what's going to happen is the name of the trust is going to also be on the name of any of your assets that you end up putting in the trust. And we could talk about funding now. And so how that works is that in order for your trust to be able to control the assets that you put in the trust, your trust has to own them, right? Just like you can only control what you own and you have authority over. So if your trust needs to own these assets, so say for instance, your bank accounts, you want to make sure that the trust is named on your account, or the trust is a beneficiary of your account. Some institutions have accounts that allow you to make your trust the beneficiary, which means if you pass away, the trust then gets the assets and the trust could do whatever rules are inside of the trust that it says that it could do. Or you retitle the account in the name of the trust, meaning instead of saying, Sabine Franco's, account, it's going to say Sabine Franco's trust account, right? Something like that, whatever your trust name is. And so that now gives your trust control to be able to do what it needs to do with these assets. So all of these rules and things that I'm going to talk to you about that the trust says, those rules and directions will be controlling those assets, right? And that's what we call funding the trust. Your trust is not alive until your trust actually owns something. So once you sign it, we fund it immediately with some sort of asset, even if it's something small, something nominal, to make sure that your trust actually owns something. And now, it is a living, breathing document. And it's funny to say it that way, but really that's how it is. That's how it is under the law. Sort of like how, we say you have a business entity and really it only lives on paper, but it's a business, it's a thing, right? Because the law says so. And that's basically how it is. So beyond the name of the trust, the other things that the trust will state, it will say, what are the powers that the person who created the trust, what powers do you have? So now that you've created this document, you've given it all these instructions, now what's your authority? What powers do you have as the creator of the trust? So typically the person who creates the trust, if it's a revocable trust, has the power to revoke that trust. What does that mean? To change it, to get rid of it, terminate it. Whatever it is that you'd like to do, you have that power. You can revoke it and then it no longer exists. You can change your mind about everything, remove all the assets, and go on with your life. Typically, that comes into play when you have maybe like a divorce or a situation where you really want to completely redo your estate plan. And I did a whole video about when you get divorced and you want to sort of undo your estate plan. So you could take a look at that. So the other thing that the creator has is the power to amend the trust. You can make changes. You can, like I said, you can change your beneficiaries. You could change the assets. You could change how much of what you want to go to whom. You can add beneficiaries. So that's the power to amend, right? You also get to control the assets, right? So for instance, your primary residence, you have the right to continue to live in that. So if you're not the trustee of your trust, which the trustee is the person who's managing the trust, if you're not the trustee, then you are the only person who gets to live in your house and, wear your clothes and your jewelry and things of that nature. Your successor trustee does not have those powers, but they can control those assets according to what the trust says. And you, as the trustee, will be able to decide, what sort of investments you'd like to do within the trust. Now, there's a lot of talk about, you need to have a trust that allows for your assets to be invested so that it can continue to grow for your heirs. Grow in the stock market. Experience compound interest, etc. So, fun fact: all trusts really are supposed to be conducted in that way. Why? Because it is the responsibility of the trustee to make sure that the trust is profitable, to make sure that the trust is productive. So if a trustee has, say, 100K in a trust account and it is just sitting in cash, then that trustee is not really making sure that that trust is being profitable, right? Because that's not the best way for that trust to grow. That's not the best way for those funds to benefit the beneficiary. So now when you create the trust and you're the trustee, you don't really have that responsibility per se, because you are the creator, but any successor trustee is going to be held liable for not ensuring that these trust funds are being productive. So yes, they do have to make sure that they're growing and they do have to make sure that they're invested. And I would just caution on not making it so restrictive. Like some people say, I just want it invested in the S&P 500 and I want to make sure, well, that's great now. Well, maybe not literally now because the stock market is way down right now. But, the S&P 500 may not be the best investment vehicle when the time comes, right? When you're either no longer here or when, your successor trustee is managing the trust. So we like to make it more flexible in the sense that, we could say that we want it to be invested in a particular thing, but we want to have some flexibility with that. So if that's not the best vehicle, that you can take advantage of other vehicles. Like, for instance, we don't know where crypto's going. There's a lot of speculation about that. It's a new thing, though. So, it may be the best investment vehicle one day, and you don't want to have to now be stuck in stocks because that's what your trust said, right? So this is the type of things that we think about as attorneys to make sure that we're not drafting something for you that's too rigid, that's not keeping in mind the things that you're not thinking about because you're not, you're not the professional. So we understand that. And we're here to basically make sure that you're protected. So you want to make sure if you're working with an attorney that they're actually strategizing. They're just thinking about, what are your goals, but they're also thinking about it in a broader sense, not just what you're, telling them essentially. Right? So that was a lot. So your trust is also going to identify who your family members are. And the reason why that is because a lot of time estates get caught up in court just trying to figure out who's actually related, who's actually an heir, who actually should be benefiting from this estate. And so when you identify who your family members are and, state whether or not there may be others or you intentionally left somebody out or whatever it is, that actually helps to solidify your decision making and it eliminates question. It eliminates the need for a judge to decide. Remember what I said? If it's vague, and there's, something to be, wondered, then someone might try to bring it into court and say, hey, I think there was a mistake here. So we don't want that. We want to be as clear as possible when it comes to identifying your family. So, who your children are, your adopted children. I don't know if I spoke about this. I think I spoke about this before, but your adopted children, legally adopted children, get treated as your children. If they're not legally adopted, like stepchildren or anything similar, or somebody who was like a child to you, they're not treated as your children. So you have to specifically state that in your estate document. So you may not name them as your children, but you may say, listen, this person is like a child to me and I'd like to leave XYZ to them, so that it's clear, that you were clear on what your relationship was and what you would like to do. All right. And that also helps your trustee to understand who your family members are and, how to basically treat everyone and how to continue your wishes according to what your trust says. Then there's some things that we talk about okay, what happens if you get sick? Like, how is the trustee supposed to handle these assets if you're sick and you need to be taken care of? So there's like a whole section about that and like who to continue to take care of and what needs to be continued and what needs to be ended and how should you be cared for and all that stuff. All that is contained in your trust. Then we talk about what happens, obviously, if you die, because that's one of the whole purposes of the trust. So how do we continue to manage these assets? Should something be sold? Should something be distributed? Should it be held in trust? Like that's a whole section of the trust. And that's one of the very, probably more robust, more detailed and technical parts, because we really have to make sure that we get that right? We don't want there to be any confusion there. And then when you're married, there are distinctions where we want to know what happens when one spouse dies, and we want to know what happens when both spouses die. And if you guys have, prior marriages or separate children, that tends to get a little bit complex. So there's a lot of sort of thought and strategy that goes into designing that section of the trust, because it typically, makes a big impact if something goes one way or another, right? Without boring you with all of those details. And we also want to make sure that, within your trust, there are sections where we talk about restricting creditors, where we talk about different strategies for your tax professional to be able to avoid taxes or make certain decisions that will allow them the flexibility to avoid taxes, so that, if there's an opportunity for you to do that, remember I said avoid, not evade, right? Avoid taxes legally. If there's an opportunity to do that, your trust allows for that language, because the last thing we want to do is for you to like lose out on all these tax savings or like a strategy that could be used just because your trust is too rigid. So there has to be some flexibility there and specific language around how your trust allows your estate to treat taxes. And typically, how would you like things to sort of be handled? If you have your assets staying in trust for your children, we want to know, like, how should that be handled? How do you want your children to experience this inheritance? How do you want your children to be protected for not having all this money come to them at once, or giving them a period of time where they can sort of get comfortable with receiving, or have a certain set of instructions as how they should, treat assets or treat businesses or treat real estate. So that's a really meaty area of your trust as well. We talk about real estate property in particular, if you have a lot or if you have real estate that needs to be treated in a particular type of way. We definitely talk about that in your trust. And then another thing that sometimes people don't think about, which I find like a lot of clients have difficulty with, is if no one is around to receive your assets. So say, for instance, if your children are not around, which is always a hard thing to sort of talk about, then what happens? Who would you like to receive your benefits? Or, whomever that beneficiary is, who you'd like to have and benefit from your estate, what if they're not around? And so we need to have a series of alternates for that. And sometimes it includes, charities and other businesses or, further removed friends and things of that nature. But it's something, to talk about, and it's something that we definitely include because essentially we don't want to create a plan for you that just halts or fails at some point because we didn't think about, those alternatives. We also talk about having checks and balances in place. What if the trustee, the person who you selected to be that trusted person, what if they do something wrong? How do you go about protecting the trust and protecting the beneficiaries? So there's language in the trust that should speak to that as well. So these are some of the, hot button topics that we have in these trusts. Again, I showed you, they tend to be pretty hefty, and this is like for a single person. So now when you have a married person who has separate children or all these complex assets, we kind of need to get a little bit more creative. So it tends to be really robust. So I hope this sort of helped you get insight into, the inner workings of a trust and why is it such a complicated thing. I mean, it's complicated and it's not, right? I don't want you to think it's complicated in the sense that it's over your head and, I'm not, equipped to have a trust. No, you are. You just want to make sure that, you work with the right individuals or the right firms to help you achieve that. And it's not just for the uber rich. It's also for you and me who, just want to make sure what we work hard for is preserved for our loved ones, and that we are also taken care of if something, if we're not able to control our assets later on. So thank you for listening. I hope this was helpful for you, and I will see you in the next episode.